I'm here today on Mr. Devonte Bulock. He was the gentleman that was sent over to take a drug test yesterday, and he's returned to court.
Bullock. Next door, I think they are.
Bullock was presumptive positive for THC and is pending a lab application.
Okay.
And he's here in the back of the court.
And he did disclose to us that he had utilized THC recently.
Mr. Bullock, you now stand charged with another burglary of a motor vehicle. So they now have you on 2 charges of burglary of a motor vehicle. I'm telling you that I'm going to do everything in my power to protect my public. I don't care how old you are. I don't care how young you are. You go out there, you start acting a fool. It's not going to go well for you. Do you understand? I just set someone's bond now at nearly $30,000 because they're out there running amok. Don't do it. I'm going to test you 50 days from today. If I find that you continue to use, it's not going to go well for you. Do you understand? We need to do probable cause on the new B&B because we haven't done it. So do you mind on the new case?
The failure to ID.
No. So there is a failure to ID. There's one B&B, and I guess later on in the day goes out and allegedly has another B&B. Okay.
On April 7th, 2025, law enforcement officers were dispatched to a burglary call in Harris County, Texas, and met with the complaining witness, who stated that around 6 a.m. he heard his car alarm going off and observed 2 males wearing all black making entry into his vehicle. Another law enforcement officer that was dispatched to that location observed 2 males matching the description in the same area, and the defendant had complaining witness's key fob on his person that was in the middle console of the vehicle. I believe when they broke it.
So that's how they put him, because he's got someone else's key fob.
Yes, Your Honor.
Okay.
Then he was identified by mobile AFIS.
I think I need to get a tag to that third one.
We'll attach you to it now. Yeah. So do you want to file I guess another one because he has a new case?
Your Honor,
One in 416?
Yeah. Or I guess we need to get it over here. You want to do a transfer? Okay. Yeah. You want
That's what I was gonna say. On my end, it was still showing.
Yes. I don't want you out in the middle of the night. I'm going to put a monitor on your ankle so I know where you are at all times. I don't want you to have any contact with the complaining witnesses in this case, and I don't want you to go anywhere where they live. You pick up a 4th case, I'm going to go haywire. Do you understand? What are you doing with yourself these days?
No, I'm gonna finish school and I'm thinking about joining military.
Not why you have all these cases open. Did you not get enough sleep last night? What?
Not really.
While these cases are open, you must either have a job or get back into school full time. When you have too much time on your hands, you become self-destructive. And the days of you just sitting doing nothing are not going to happen. I'm bringing you back in 2 weeks and I want to see what you have done to get a job. If you have done nothing, it's not going to go well for you. Do you understand?
That's not.
Do you have an ID? Okay, I want you to start going and applying for as many jobs as you can, or you get back into school. While these cases are open, military is not going to take you. I don't think if that's something that you want to go do, that would be great because that would give you great structure, which you probably really need. I mean, the military would be a fantastic idea for you that would really, could potentially put you on a career path that could just lead you to the clouds. Really, what you're doing now, you're charged with 2 counts of burglary. You know what that'll do to your career? Who hires burglars? No. You think you won't even get financial aid with that kind of stuff? Really, it will hose your whole career. So for now, you must either get a full-time job, start looking into going back into school, but you doing nothing, it's not going to happen. Do you understand? All right. So what we'll do is we'll bring him back in 2 weeks. We'll see what he's done. I'm going to test you 50 days. Don't use. And I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
That's not.
If I find that you're out past curfew, I will revoke all of your bonds. They're going to go high. Okay. Thanks. All right. Take care, Mr. Bullock. Mr. McQueen, you're charged with indecent assault. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and won't be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 4th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a sexual assault call and made contact with the complaining witness, who stated that her and the defendant, her stepfather, were on their way home. The defendant began talking about the CW's boyfriend and then stated he wishes that she was his so he could, and this is quoting directly, Your Honor,
Say it.
taste her, fuck her, and that her innocence draws him towards her. Once inside the residence, the defendant came up from behind the complaining witness, wrapped his arms around her, and proceeded to kiss and lick the side of the complaining witness's neck. The complaining witness attempted to get away from the defendant, but the defendant restrained her until they fell on the floor. The complaining witness was able to break free, run to her room, and lock the door. The complaining witness is snapped in the door.
Mr. McQueen, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. I'm now issuing what's called a magistrate's order of emergency protection. This is a court order that identifies her as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this court order, the state can and probably will file a violation of protective order, and that is the capital murder of misdemeanors. Don't pick up a violation of protective order.
Yes, sir.
You're ordered not to have any contact and not to be in possession of weapons. Okay. Okay, so now we need to talk about a bond. Guys, what say you?
Your Honor, due to the nature of the case and the defendant's criminal history, this state will request a $5,000 bond. You said.
What, was that 5,000, Judge? 5,000 is fine, Judge.
Okay, I'm gonna set your bond for agreement of the parties at $5,000. Do you have a bonding company here now?
We do.
Okay, I'll allow you to walk out with your bonding company. Do not pick up any new cases. Do not. He has 2 prior AFMs. One of them against the same complaining witness. Can you please let me know?
Yes, Your Honor, if I can just have a moment.
No, I know. He told us that.
I don't know if, I see
It's
2
not the-
AFMs.
not the
I'm
same
just not.
I don't believe it is the same person, Your Honor, from what I have. Agent case.
Like 10 years ago.
It is not some complaining witness, Your Honor.
Okay, so we'll set your bond at like I said, at 5,000. Don't pick up any new cases. Don't do anything to violate the conditions of this bond. Otherwise, it's not going to go well for you. Do you understand?
Yes, sir.
All I want is my community safe. I'm going to do everything in my power to protect it. So we'll have you now, since reset or no?
Are they posting their own bond?
Yeah,
Then we don't.
yeah, we're not going to do a reset at this time because what'll happen is he'll get a 7-day, we can't essentially. So once he goes post bond, you will get a 7-day setting. Just reach out to Victoria, email, and then we can give you a further date so you just don't have to come back in a week.
Thank you, Judge.
We'll have him sign all his conditions. Now, do not leave until you sign your conditions, and after that, we'll let you go. And then we'll let him go to the bonding company.
Thank you.
Yeah. Okay. Thanks, guys. Right. Both of you are charged with criminal cases. You're charged with driving while intoxicated. Both of you have breaths over 0.15. That makes it now a Class A misdemeanor. You are facing a year in jail and or a $4,000 fine. Both of you have negotiated plea bargain agreements for essentially slaps on the wrist. After today, each of you will be facing 90 days in jail for any other DWIs that you pick up. And I will tell you now, if you were ever in a car, you get pulled over, first thing officers do is they look at your record. If they see that you have prior DWIs and they go up to your window and they smell alcohol or dope, it's probably not going to go well for either of you. So if I were you, I would never get into a car and drive, even if you've had a sip of alcohol, because you're taking a huge risk, especially if you're not in this country with permission. Do each of you understand?
Yes, sir.
A minimum of 90 days in jail from now on. No more slaps on the wrist. Both of you give up a lot of rights by entering into these agreements. You're pleading guilty to these charges. They will go on your record. They will be there forever. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. Both of you give up the right to appeal as well, meaning that once you plead guilty, there's no changing. Do each of you understand?
Yes, sir.
Is this what you want to do?
Yes, sir.
Yes, sir. Yes, sir.
How do you, each of you plead to the offense of driving while intoxicated?
Guilty, sir. Guilty,
I
sir.
want you to understand that everybody makes mistakes. When you continue to make mistakes, when you endanger other people's lives, that's when we really come down hard on you. There is a $4,500 surcharge that would normally apply with these types of cases. I understand that mistakes happen, and I will take it off of you now. But if you make another mistake and you pick up another DWI, a second DWI, it's a surcharge of $6,000. And if you don't pay it, every $100 you owe, you sit 1 day in jail. Not to mention the minimum 90-day sentence that there is. So get a clue. If you want to drink 32 beers, 52 shots of tequila, take an Uber or find another way to get around. Do you understand? I'm
Yes, sir.
suspend both of your ability to drive for 90 days. Do not drive. Otherwise, we'll be back here. Mr. Chirinos, I'm going to sentence you to 6 days in jail. I will give you credit for the 2 days that you have done. Mr. Hernandez, I'm going to sentence you to 3 days in jail. I will give you credit for the 1 day that you have done. Good luck to you, gentlemen. Thank you.
Vamos.
Okay. Mr. Pullard, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On April 7, 2025, in Harris County, Texas, officers a theft trafficking call and an off-duty officer who had detained the defendant and a co-defendant. The off-duty officer was informed by mall security that the co-defendant stole merchandise from Zoomies and passed all points of sale and ran out of the store. The co-defendant then ran to a car in the parking lot where the defendant and another individual were located. So the blocked in the vehicle and were able to detain the defendant and the co-defendant. Officers found a handgun in the glove compartment of the vehicle. Then said the handgun belonged to them. And the officers observed a strong odor of marijuana.
You officers what?
Observed the strong odor of marijuana.
Okay.
The defendant then stated he had weed or marijuana in his pocket. The officers retrieved a bag of a leafy green substance from the defendant's pocket.
He's a passenger though, right? Or was he the driver?
I believe he was the driver. Let me make sure that's correct, Your Honor. He was in the driver's seat.
Mr. Pullard, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run his license, please?
Yes, Your Honor.
What do you do in life these days, sir?
I just finished electrician school out in Port Arthur. I
Great.
just moved back to Houston.
Did you get your license or no?
Only thing I have from there, the school was like an OSHA 10 certification, but and basic training of electrician, but it's more classes I have to take to
Get on it, doggone it. What are you waiting for? You know?
It's just a lot. I had a lot of family issues going on with like moving back and forth from Houston and Beaumont. Where I was staying in Beaumont, our house, during the storm, it messed up. But I was only staying out there because of the school. But now our house is getting
Are
repaired.
you living here in Houston now? Okay. I'm going to appoint your lawyer today, Mr. Pollard. I don't want you to get in any more trouble and I don't want you to use. You're not to be in possession of weapons. I'm going to test you 50 days from today. If I find that you're using, it's not going to go well for you. You understand? I don't want you hanging out with the co-defendant in this case as well. You know, you're on a fast track to nowhere. You have the opportunity to get a really good job. Electricians can make, a killing if you do it well and you get on it young while you're now. But I'm telling you, this is not a good way to start. Do you understand? So I'm bringing you back in 2 weeks and I want to see what you have done to further your electrician career. Get back into school, get back into so you can get your license. Do you understand?
Your Honor, his driver's license is eligible.
Great. You may drive as long as you have liability insurance as well. You cannot drive unless you have car insurance. You understand? I'm making that a condition of your bond as well. Okay, so to test in 50 days, no alcohol, no illegal drugs, and back in 2 weeks to see what he's done for school or work. Okay. All right. I'm going to appoint your lawyer today. You're going to sign a reset with Victoria. You'll meet with Anthony for pretrial services, and then we'll have you take a seat in the jury box. Please. Good morning, Mr. Williams. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Thank you, Judge. On 7/2025 in Harris County, Texas, officers were dispatched for disturbance. Officers made contact with the defendant who had blood on his face near his beard and lips and denied that anything was happening. The officers then met with the complaining witness who had a large wound on the bridge of her nose and was still bleeding. Officers also observed blood on the hood of the car. The complaining witness stated that the defendant is her boyfriend who had come home and started asking her, "Where is the other guy at?" And then proceeded to punch the complaining witness in the face, causing bleeding. That's it. Yes, Your Honor.
Okay. All right, sir, I'm going to find that there's sufficient probable cause to go forward with your case. There's a protective order that has been issued in this case. Get to know it. If you do something to violate the protective order, the state can and probably will file a violation of protective order. It's one of the worst cases you can pick up. At this point, do we know whether she wants to have contact with him or not?
You just have one moment, Your Honor. There's a good call.
I don't know if she wants to have contact with you or not. Until we know whether she does, I want to honor her wishes. If she doesn't want to have contact with you, I'm going to order you not to have contact with her. If she does, then we can modify the conditions. I just don't know at this point.
Your Honor, may I say, I spoke with her, as a matter of fact, yesterday. She reached out to me because she wanted to do an affidavit of non-prosecution, and she wanted this case to be dismissed, and she did want to have contact. Of course, I advised my client that there's a protective order in place, so regardless of what she wants, unless the judge gives permission, he couldn't. But from my understanding,
The state can confirm that, Your Honor.
You can confirm?
Wants contact.
Okay, so I am going to order you at this point not to have any threatening or harassing contact with her. You need to understand that what is threatening or harassing doesn't matter what you think. I don't care what you think. It's what she perceives. So if you go like this to her, that is most certainly threatening, harassing, and it can land you right back in jail. There's a lot of addictive people in this life, and I don't know what kind of relationship you have with her. But if it's something that you're constantly butting heads, I'd be very careful because she calls and makes the slightest, you're the one that's going to end up back in there. Do you understand? All right. So what we'll have you do?
That's a different, different.
Oh, this is not that. So I'll modify the bond condition. What I'm going to do is I'm going to take off the residential restriction. However, everything in this order still applies and the stuff that you shouldn't do anyway. So make sure you read it and know what it is. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells you that she can't get a hold of you because you're playing games, you pick up a new case or you become a danger to my community, it's not going to go well for you. Do you understand? Good. I hope so. All right. So we'll have you sign a reset. Don't leave until you sign our bond conditions, and after that, you'll be free to go. Yes, ma'am.
A young man with an electrician's certification sat in court on a weapons charge, one wrong turn away from a career that could have made him financially secure. His stepfather sat in the same courtroom charged with sexually assaulting his stepdaughter. Both walked out the same morning on bond. American law treats these two defendants identically at the pretrial stage, both presumed innocent, both entitled to bond. But one poses a risk of property crime, the other a risk of sexual violence against a family member already in his home. Should the nature of the alleged harm, not just the defendant's criminal history, carry more legal weight in bond-setting decisions than it currently does?
I was appointed to Mr. Mendoza on your in-custody docket. He has 2 cases of assault, family violence, that was a prior bond forfeiture, and a failure to ID. I was appointed this morning on those cases, and we have filed bail orders.
Okay.
On the older, we're requesting PR bonds, sir. On the old assault, family violence, he did let me know, he was in communication with his attorney, and the his appearances were being waived over in ERD court. I do show a reset from July 1st saying he doesn't need to appear and setting it for July 3rd where he does need to appear and his signatures are not on it. And he said he did not know. But
He picked up a felony violation of a bond condition.
that's correct, Your Honor. That was filed as a 2B warrant.
I don't know anything about the cases and I haven't spoken to him in a very long time. Does he speak English?
He does, yes, sir.
Great. I'm going to have him. Is he bringing him up? He is not made bond on the felony case. So.
That's correct.
Good morning, Mr. Mendoza.
One time.
Sir, you're charged with 2 cases with us. You were charged with assault of a family member. You're now also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That allegation kicks it up to a Class A, so you're also facing a year in jail and or a $4,000 fine. This case the assault is a year old. I have no idea what is going on with it, so I'm going to have you refresh my memory real quick. What happened, please?
On the AFM?
Please. On all 3.
So on the AFM, which is the original charge, On April 6, 2024, officers spoke with a complainant witness who stated she was involved in a physical altercation with the defendant after the defendant became upset with her over food and struck her several times with a closed fist in the nose and mouth, causing her pain and visible injury. Officer observed the complainant witness to have a swollen bottom lip with a small laceration, and she was holding a bloody towel that she used for her nose. Defendant was identified by his Texas driver's license, and the defendant and the complainant witness have been in a dating relationship for 8 years. So that's the oldest AFM. Do you want me to do the felony?
Yeah.
Okay.
What?
So on the felony, on June 4th, 2024, officer responded to a disturbance call and spoke with the complainant witness. Complainant witness stated the husband threw her on the wall after she called his mom to complain of his behavior. Complainant witness said she had a protective.
I didn't hear any of it.
Okay. Officer, on June 4th, 2024, officer responded to a disturbance call and spoke with the complainant witness. Complainant witness stated that her husband threw her against the wall after she called his mom to complain of his behavior. And then she stated that she had a protective order against the defendant. And then the failed to ID. On April 11th, 2025, officer dispatched to an unknown disturbance call for service. Officers arrived on scene, knocked on the door. Officers observed a male come to the door, but quickly moved out of the way, not wanting to answer the door. Officers observed the defendant walking out of the door, stating that he was only having a verbal argument with his wife.
So it's now a new fight with, and that's what brings the cops to the house?
I believe so. Officer spoke to the female on scene. Officer stated the female was not answering questions due to not wanting to get the defendant in trouble. Officer observed the name and date of birth the defendant provided to officers for not coming through a TCIC search. Officers advised the defendant that if he does not have proper name and date of birth, he'll be charged with failure to identify. The defendant then confessed and provided his real name and date of birth. The defendant stated he did not want to go to jail for a warrant that he had. And then the officer observed that he had a felony and a misdemeanor warrant.
The reason I'm trying to, you speak English, right?
Yes, sir.
The reason I'm trying to figure what's going on is because she's asking me to give you a PR bond, but we've given you bond after bond after bond. You've been in flight status for about nearly a year. And now when the cops come to try to talk to you, you try to evade again. You know what I mean? Are we just going to continue to give you chance after chance? You continue to just don't give a shice about bond conditions, man. Really? I mean, you know, I get it that he may have not signed it or whatnot, but you can't just be out of sight, out of mind for an entire year and expect good things to happen. I mean, really, we've given you PR bond after PR bond. It would just, at some point, I have to say when, so that you know we mean business. There's no more revolving doors, you know? Really?
The original AFN, it looks like they did do a RIP call. The complainant advised that the reason that she had a bloody nose is because she does drugs and was doing cocaine. He did have the PR bond. The VPO was a 2D warrant, so he wasn't given bond and didn't come on that one.
Yeah, but he had a warrant sought for both. Apparently knew about them. So,
Well, it didn't say that he knew about the felony warrant.
Well, I don't know, but
You can't make believe that he knew.
I mean, I can, if you want a bond reduction, I'm willing to give you a bond reduction. I'm not going to give you another PR bond, dude. Really, I'm just, no more PR bonds. And you know, you've got these cases out. Just, you can't out of sight, out of mind. And the only reason you're here now is because you got into another damn argument. So, Mr. Mendoza, I am now issuing another protective order on this case. And I want you to understand that the Texas Constitution does not allow me, but in extremely limited circumstances, to have a hearing to hold someone at zero bond. This is now one of those cases. If you continue to violate protective orders, we can have a hearing to hold you at no bond. Do you understand? I don't want you to have contact with this person. No means no. Doesn't mean, please, baby, get me out of jail. Every phone call is recorded. Take note when you're making phone calls. Every phone call is recorded. Do you understand?
Yes, sir.
I'm not asking for much. All I want are my streets to be safe. And if you can,
Yes, sir.
just don't have any contact, don't have any weapons, and that's it.
Sir.
If you want a bond reduction, I'm happy to give it to you, but I'm not going to just continue to give homeboy PR bond after PR bond after PR bond. Just not, you know.
Would the court be willing to reduce the bonds for $1,000?
I'll cut it in half. So on the assault, 2,500. I'm going to leave the failure to ID as is. But I'm telling you now, I don't know if you're going to get out, but if you do, there is a residential restriction. You cannot go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
No alcohol, no illegal drugs. You will be randomly tested. No contact and no weapons. Do you mind? All I need you to do is file the MOA because we'll have him, pretrial is going to, make sure that you're in compliance. All right, Mr. Mendoza. So what we'll do is the felony case is set for June. So what we'll do is, I don't like to set the people for more than 30 days so you just don't get forgotten about. Well, we can set you for 30 days, come back, and then, go from there. Okay? All right. Yes, ma'am. Thanks. Are you doing a plea?
No, this is an arraignment, but they also have a plea.
Santimanes?
Is an arraignment.
109 days old.
Yes, apparently, we just got hard on this case. Apparently, he's supposed to come to his first setting. But he tells me he couldn't get a ride, so he didn't come. So here we are. He posted a new bond. So it's as though we're starting over. So I just need to look at the discovery and then we'll go from there. It's a .07, not .076. Expired.
Mr. Santimanes, you are charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Judge, on December 27, 2024, law enforcement officer was dispatched from Cleveland Street and Allen Road to back up an officer on traffic stop. Law enforcement officer had stopped the defendant's motor vehicle for expired registration and loud noise and vibration. The law enforcement officer made contact with the defendant, the driver, and law enforcement officer observed the defendant spraying cologne over his body several times. He also observed the odor of alcoholic beverage, red watery eyes, slurred speech, and the defendant stated that he was drinking alcohol at an unspecified time with some friends at a trailer park. The defendant's girlfriend requested they meet, which is why he was driving. The defendant consumed 3 bottles of 12-ounce Modelo beer approximately an hour prior to the law enforcement officer contact. Serious sobriety test was administered. And the officer observed 4 or 6 on the HDN, 4 on the walking turn, 4 on one leg stay. And while administering the HDN, the defendant had a distinct side-to-side sway.
You say side-to-side sway?
Correct, Your Honor.
Okay.
During the walking turn, the defendant used his arms for balance, military test, and hopped to maintain balance for approximately 2 seconds. The defendant consented to a breath test and to .076 and .073.
Okay, Mr. Santibanes, I'm going to find that there's sufficient probable cause to go forward with your case. Any prior to DWIs? Does he have a license?
Yes, Your Honor.
No prior to DWIs and his license.
Okay, as long as you have a valid Texas driver license and liability insurance in your name, you may continue to drive. I am ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, it will not go well for you. I will put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they can put an immigration detainer on you and you will be stuck like Chuck in there until this case is over with and then you get shipped off to immigration. Do you understand?
Yes.
So your case is now 109 days old. We don't set cases very long after for trial, so get ready. Do you understand? Okay.
Yes.
I'll have you sign a recess with Victoria. After that, we'll have you meet with pretrial and then you're good to go. Hey, good morning.
Pre-counsel, your docket again. We work out a 4-year deferred upstairs. And he's applying for interstate compact. They pushed us to Monday to get the supporting documentation. Judge, I talked to Mr. Jurisic by email yesterday, and he's made a time served offer on the DWI here. I wanted to see if that's something the court's willing to accept, but that time
It's a
served.
first, right?
It is a first.
I'm okay with that.
That offer is dependent on him entering the plea on the deferred. So if we'll push to Monday, he's got a plea on the deferred to get he hasn't pled on the deferred because we've pushed to Monday so he can apply for interstate compact. Because he's California resident.
Come up, Mr. Greathouse.
Is that okay? Okay, just check. Probably around the 180 mark, I think it was.
Of course, there's not a problem with it. Again, you have to be very, very careful. here in our court, we do the fugitive cases. So I handle all the cases here where someone gets arrested in Harris County for an open warrant they may have in any other state, Wyoming, Delaware, California, Oklahoma. If you have a warrant that originates in another state and you're arrested here in Harris County, I handle all those cases. One of the cases that is most difficult and frustrating to deal with are the interstate compact cases. Because, and she's shaking her head over there because it really is, she's our fugitive prosecutor. Because if you do something to violate conditions where they have to issue an interstate compact warrant and you end up in jail, you will sit there for months on end waiting for anything to resolve, waiting for the interstate compact people to do whatever they need to do to resolve cases. So if you are getting on this deferred upstairs, which is a very serious deferred, right? And you violate conditions and they have to issue a warrant, you could be months upon months sitting in jail. So the only thing I'm trying to tell you is take it seriously. Don't take it as a joke. Everything is done on timing, so you got to do stuff on time. Don't take off. It's the worst thing that you could possibly do when you're on a deferred. Just do what you're supposed to do, and everything ends up well. When you don't, on these interstate compact cases, it's a complete nightmare. You want Monday?
Yeah, please.
Absolutely. Okay, so we'll push you off Monday and then we'll see you. Okay. This is on Helsinki. Al-Salkini.
Yes, Your Honor. That's the only issue we may run into.
Okay,
Your Honor, we have reached a resolution in this matter. The state has made another offer, which my client is interested in. However, I'm taking into consideration the language barrier here. I'm not sure, but I have to
But I have
double
a
check.
translator.
No, I'm saying, he understands that an offer is a bit class. The thing is, I'm trying to split the bid class is offered in Arabic. That may be the only thing.
It's an online.
Yes, I'm quite sure they can.
Hold on.
Yeah.
It's an online bid class.
Yes, sir. I haven't seen one, so I didn't want that to be an issue when it comes to timeliness.
I usually have experience on these courses. Usually they provide an interpreter.
Okay. They'll
Even
provide.
for the, even for the classes.
Okay. Is that something we have to request prior to?
Yes. Yeah.
Okay. Okay.
For each class.
Okay.
I'm sorry to just interrupt. I was just sharing my experience.
Okay. Because most of them I've seen are English or Spanish, but I didn't know if that would be.
Arabic and French too.
Okay.
So how are we going to get that done? I mean, his case is 227 days old. I'm going to give you guys a couple weeks to get it done.
Yes, we can figure it out. I'll figure it out.
And then I'm going to tell him I'm setting his case for trial.
I'll figure it out.
So-
if she gave a possible alternative as far as getting an interpreter in to assist with the course, so I can.
Mr. Al-Salkini, come up.
I didn't know that was out there, an option.
Okay, guys, I'm going to have a translator interpret, so please keep quiet. Okay, Ms. Kuja, thank you for coming. Will you raise your right hand? Do you solemnly swear to interpret word for word what transpires here?
I swear.
Okay, thank you. Mr. Al-Salkini, you were charged with assault of a family member.
مرحبا أستاذ السكين. أنت هنا اليوم بتهمة الاعتداء على أحد أفراد الأسرة.
Your case is old at 227 days.
ملفك قديم هو 267 يوم.
It appears that you have worked out a plea bargain agreement that you wish to accept.
حضرتك اتفقت على إدانة اللي ناقشت إدانة واتفقت عليها. حابب تتفق على هذه الإدانة. Yes.
Due to the age of the case, I'm giving you 2 weeks to complete this class.
بما إنه الملف قديم راح أعطي حضرتك أسبوعين من شان تخلص الحصص.
If it is not complete, your case will be set for trial.
إذا ما تم انتهاء أو استكفاء الحصص بأسبوعين فراح أرسل ملفك للمحاكمة.
Okay, so we'll give you whatever day you want, and then we'll see you in 2 weeks.
Yes, sir.
Okay.
Thank you.
All right.
Have
Good luck, sir.
Thank you, so.
Thanks. Let's dance.
We are approaching on Mr. Cassius Bond. He's in custody, fugitive case.
Bond?
Bond.
Bond wants a bond?
No, he does not. He signed a waiver. We're approaching to see, do you want to admonish him? Which I think he would need.
So what's the problem? What happened? Because I can't look at anything. Nothing's working.
Judge, he has cases from Tennessee. I'm not sure that's what you're asking, but he hadn't signed a waiver yet. We just got that
Okay,
signed.
so yeah, do you mind bringing up Mr. Bond? All right, so theft of property, identity theft times 10.
Yes.
Fraudulent use of a debit card, 60,000 to 250,000. Wow. And he's on deferred for burglary of habitation.
That I believe he just took.
Yeah, he just,
Yeah,
And he wasn't aware that he had a hold whenever he took that offer.
Good morning, Mr. Bond. Shh. So the reason I'm bringing you out now is you need to make a decision on what you would like to do. You are wanted out of the state of Tennessee, specifically the county of Rutherford, for theft of property, 60,000 to 250,000, identity theft times 10, fraudulent use of a debit card from 60,000 to 250,000. You're wanted for those whole host of charges. There are two things that you can do. Well, specifically three things. So they want you. You can either waive extradition. If you waive extradition, we give Tennessee 14 days to come get you. If they don't come get you within the 14 days, Harris County releases you. If that happens, that warrant will always remain in effect. And it will always remain in effect until you go back to Tennessee and take care of it. The problem is if you don't, at some point, it's going to hose you because you just entered into a deferred upstairs on a bird hab. So if you are in the middle of your deferred upstairs and then all of a sudden you get taken there and you spend 2 years there, you're going to get hosed on this probation here. So the idea is that you try to take care of everything now while you're still have the understanding of upstairs. Do you understand?
Yes, sir.
The other thing that you can do is you can request a bond, but I don't know if I'm going to give you a bond. The other thing is you can fight extradition by saying, hey, it's not me. They got the wrong person. So what I can do is I can, put you back now, have you talk to the lawyer that we've appointed you to see what you want to do. Okay? Do you have any questions?
Yes, sir.
Okay. I guess let me know what you want to do and we'll go from there. Yeah. Okay. Thanks.
Morning, Judge.
Hi.
I'm here on an off-docket matter. It's a request to amend bond conditions that is unopposed by the DA's office. My client, I guess we'll give the case number.
What's the cost number?
It's 2553235.
Is this on Miss Iwoma?
Yes, it is, Your Honor.
Okay.
Situation is that her husband has been given a promotion and in late May, I think May the 27th, 26th, is being transferred to Blythewood, South Carolina, which is near Columbia, South Carolina.
Okay.
And she would request that she be allowed to go to South Carolina with her husband and appear either virtually at court appearances or be allowed to fly back to Houston for court appearances.
I don't think that there are any travel restrictions now, but it's a DWI second. So she must still comply with the conditions that she has as far as whether she has an interlock, whether she has a scram, whatever the conditions are. I'm okay with her going. I don't care where she goes, as long as she's in compliance with the bond conditions and she doesn't pick up any new cases. That's my only concern.
That's fine.
Did you get the cause number, Anthony?
Did we want to make adjustments to the random drug test requirement?
No, I don't want to do anything special. I mean, she's got to remain in compliance. So the problem is that she may get called upon to do drug or alcohol or drug testing. If she does, she's going to have to go to a Quest diagnostic wherever she is. She could get that done there. I will not accept Punka City, a better drug test, because I want a reputable lab that's ASCLAD certified, and I know that's not something where you can just buy a result. And I think that Quest is, pretty reputable. So if she gets called upon to do a drug test, she needs to go to a Quest, and it's on her to get it to you guys, to get it to us, so we know. She's still going to have to come down. Does she have an interlock or does she have a scram? Well, she's still going to have to come down to get it calibrated.
Okay.
So So that's on her to come down to get it calibrated. And I don't know how often. She probably does that like once a month, I would imagine. So she's still going to have to get that done. That's not something that you can do remotely. So as long as she's in compliance, I'm okay where she goes there.
It's in the calibration period, you get every 2 months. Could you extend the calibration to every 60 days rather than every 30?
Because then I don't know if she's like out there and it'll take a while for me to, because I mean, theoretically, I'll extend it to 60 days. It's going to get her time to get over here. It takes me at least a couple weeks to get it. So if she drinks on that day, I'll get the violation in 90 days. And then it just,
Sure.
yeah. So the thing is I can't show you guys favorable treatment that I wouldn't show to anybody else. You know,
All right.
I want to be fair to every single person. Everybody gets treated the right way. So they're the same way. So I'm not saying no, but you just have to comply with the conditions.
Okay.
It may be more arduous because you're going there, but hey, that's the cost of doing business.
Can she, when her court's appearance is set, she needs to, I'm sorry?
Your appearance is waived.
Oh, okay, perfect.
We waive everybody's appearance. As long as you're in compliance, we may never even see you. Well, this is a second, so it's definitely gonna, you know, at some point, we're gonna see her.
Right, calculation done. All right, well, that's all we have, Judge. Thank you for your time.
Sure.
Thank you very much.
New sessions in, today brought something quietly remarkable into view. A court interpreter was sworn in on the spot so a man could understand a 2-week deadline in his own language. A defendant was told he could move to South Carolina and calibrate his interlock device every 60 days. An 18-year-old burglar was told the military might be his best path forward. None of these moments made headlines. None of them involved dramatic legal arguments or life-altering rulings. They were just the ordinary work of a court trying, case by case, to find solutions that the law permits and the situation demands. But ordinary work, done well and consistently, is how systems either serve people or fail them. 12 sessions, hundreds of defendants, one courtroom. What stays with you is not the worst of what you saw. It is the relentless, unglamorous effort to keep each person connected to something better than where they are right now. Whether that effort is enough, whether it ever can be enough given the scale of what arrives at that door every morning, is the question that no single judge in any single courtroom can answer alone.
Bennett?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Now 21 cases. Just since 2020, possession 1 to 4, unauthorized use, possession 4 to 200, 21, evading arrest, felony theft, felony assault, felony possession of a controlled substance, possession of a controlled substance, possession of a controlled substance, now 24, possession of a controlled substance, possession of a controlled substance, assault, unauthorized absence from correctional facility, PCS, now 25, just in 25, PCS, unauthorized use, and now you have an evading arrest.
Those guys.
Stop. I didn't ask you to say anything. You missed court, and now you're here. If you ever miss court again, and let me tell you something, Mr. Price, I'm going to do everything in my power to protect my city at all costs. If I find that you are one iota of danger to it, it's really not going to go well for you. Do you understand me? You're now charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge. On April 14th, 2025, in Harris County, Texas, an officer was patrolling the area of 999 Pasadena Boulevard, the Macro Plaza Mall. The mall was closed during the early morning hours when this incident occurred, and no maintenance or cleaning personnel were on scene. 999 Pasadena Boulevard is near 1202 Pasadena Boulevard, which the officer knows from training and experience to be a high drug area. The officer observed the defendant standing near a mechanical box on the side of the main building of 999 Pasadena Boulevard. The defendant looked at the officer, who was in a marked patrol unit, and began walking toward his bicycle, which was laying on the ground nearby. Due to the above circumstances, as well as defendant's suspicious behavior, the officer initiated a subject stop on the defendant due to reasonable suspicion. The officer activated emergency traffic lights and began sounding the siren of a marked patrol unit. The defendant continued to ride his bicycle away from the officer, standing up on the seat of his bicycle to accelerate faster. The defendant eventually fell off the bicycle and continued to evade on foot until he fell in the roadway of the 900 block of Pasadena Boulevard. The defendant evaded the officer for approximately 736 feet.
The hell was he doing wrong? Riding a bicycle while white? He's not doing anything. Just presumptive police. No. Mr. Price, I'm going to find that there's no probable cause in your case today. We have enough death, dismemberment, and danger in our town as it is. Don't create any more. You know, be a good person. It's not hard. Get a job, do something with your life before something, or you end up with a 25-year sentence. You know, it's lickety split. Something happens. Life is too short to end up in a 6x9 with a 25-year sentence. You know what I mean? Really. Please take a seat.
Good morning.
Ma'am, you're charged with assault, causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that you're making a lifetime decision today where this assault is going on your record and it will be there for the rest of your life. You can never take it off. From now on, you'll be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
I'm facing 90 days.
If you pick up any more cases,
Oh, yes, sir.
you're facing a minimum of 90 days in jail.
Yes, sir.
You're giving up the right to, is this on doctor? It's on doctor. Giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand?
I didn't understand that.
This isn't like Target where you don't like it. Oh man, this is hurting. You can return it. No, once you plead guilty, it stays with you forever. You never change it. If you're not guilty, don't plead guilty. It's just that simple, really. Don't, because you'll always live with regret.
Sir, I was assaulted first.
I can't talk to you about the case. You're telling me that it's self-defense.
A child a day? She's gonna show up.
She won't. Excuse me. I'm happy to give you more time to discuss it. Just, it's probably not best here. I live stream, so.
We offer tomorrow, Your Honor.
Sure.
Okay, thank you, sir.
Good morning, Mr. Valentino.
Good morning.
Sir, you're charged with illuminating an aircraft with a laser pointer. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 6-month deferred adjudication. This is a very serious agreement that you're entering into now. This is a type of probation that if you complete successfully, you do not end up with a conviction on your record, but you cannot tell people it was dismissed. It doesn't get dismissed. You do a probation, complete it successfully. If you do, and you don't end up with a conviction. Do you understand the difference? You give up nearly every right known to man by entering into this agreement, telling us that you can complete this. And if you don't, you're facing an entire year in jail. Do you understand? You're giving up a lot of rights. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this until you complete it successfully or it gets revoked. If you do something to violate this agreement, like you pick up a new case, you don't do your class on time, you don't do your community service, I'm going to issue a warrant for your arrest, and we're going to have a hearing to see if you violated. If you do, you're looking an entire year. Do you understand? You still want to do this?
Yes, sir.
How do you plead to the illuminating an aircraft with a laser pointer improperly? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold it for 6 months. You will do an effective decision-making class, thinking for a change. No drugs, alcohol, 25 hours of community service. Did you graduate from high school? Okay, what are you doing now?
Electrical. I do electrical.
Huh?
Yeah.
Okay. I want you to maintain full-time employment while you're on the probation as well. I'll make you a deal. If you do well, you get everything done quick, I'll take you off in half the time. Meaning get your classes done, be nice to everybody. And if you do that, we can take you off in half the time as a reward. But if you mess up, it's not going to go well. Do you understand? So, all right, Blake. Good luck to you, sir.
Thank you, Judge.
Thanks, John. Mr. Aguilar, you're charged with failure to stop and give information, striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You're also charged with theft, a Class A misdemeanor where you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. Law enforcement officer spoke with the complaining witness who stated that on April 2nd, 2025, he parked his truck in his company's parking lot, locked the truck, and when he returned the next day, his tailgate was missing. An employee of the complaining witness searched Facebook Marketplace and found a tailgate that matched the complaining witness's stolen tailgate and had recently been published. The law enforcement officer executed a sting operation to purchase the tailgate from the defendant, the seller, on Facebook Marketplace. He paid the defendant $140 for the tailgate. The defendant was subsequently arrested. The complaining witness stated the price to replace the tailgate was $1,117.65. The defendant stated he buys the tailgates from a friend for $75 and resells them for typically $300 to $400.
We have him taking the actual tailgate, right?
Yes, Your Honor, that's what it says. Well, it has him as the seller of the tailgate.
Yeah, I didn't take the, Your Honor.
Stop. Don't say anything. You have the right to remain silent. Exercise that right.
Yes, Your Honor, it has him as the seller and that it was recently published 2 hours ago on Facebook Marketplace. But those are the facts as far as the dim summary goes.
It says here that this defendant did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, namely a tailgate owned by Jonathan Smith. Did he take the actual tailgate?
Your Honor, there are no facts alleged in the DIMS that he knowingly took the actual tailgate. However, the tailgate was in his possession and under his control.
Sure.
He was the seller on Facebook Marketplace. There's no information in the DIMS, though, that represents that he was the actual individual that stole the tailgate. In fact, when the officers interview him, he says that a friend, he buys the tailgates from a friend and then resells them on Facebook Marketplace.
Are we to assume that he knows that they're stolen? You know, he's charged with theft, right? It's a specific and crime. So if he's selling stolen property, somehow there has to be evidence that he knows that it's stolen. How do we know that he knows it's stolen? We don't operate on hunches.
Your Honor, there is also an allegation, or it's alleged in the DIMS that the defendant told the law enforcement officer that he was aware the tailgate was stolen.
Well, there you go. Okay.
Thank you. It's my fault.
Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward in the theft case. What about the failure to stop and give information?
Failure to stop and give
Let's see. We need to do probable cause on that one as well, please.
Yep. Law enforcement officer was following up on this case in the original report. The defendant's vehicle struck a metal gate at an apartment complex. A witness looked out her window and saw the suspect vehicle and photographed the driver and passenger as they exited the vehicle. Law enforcement officers ran the plates and had the vehicle and owner information. Law enforcement officer later observed the defendant's vehicle in front of the residence. The vehicle had significant damage to the hood. The law enforcement officer made contact with the driver, the defendant. The defendant was ID'd to be the vehicle owner. The defendant stated he loaned his vehicle to an acquaintance he only knows through Instagram. The defendant showed the law enforcement officer the man's Instagram named Go Get a Veil. The defendant claimed that this man needed to borrow the car to pick up a girl. The defendant stated he would obtain the man's real name and provide it to the law enforcement officer by the end of the day. The law enforcement officer was not contacted by the defendant again. The law enforcement officer took a still shot on his body-worn camera of the defendant during the conversation. The law enforcement officer later compared the photos and saw the defendant was the same as the photo from the reportee. The law enforcement officer attempted to contact the defendant and could not. The apartment complex's estimated damages are $2,000.
Mr. Aguilar, I'm going to find that there's sufficient probable cause to move forward on both of your cases. Can you tell me if he has a license to drive, please? Texas driver license.
John, can you check that on Agular?
Yeah. Don't. I know that you are itching to say stuff. Don't.
Oh, no,
You
no,
have the
sir.
right to remain silent. Exercise. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. So
Sir.
just now's not the time to fight your case. You will have the opportunity to fight it. Just now's not the time. I want you to understand, Mr. Aguilar, I will do everything in my power to protect my city at all costs, including property. And if I find that you're a danger to my city, I'm going to lock you up and I'm going to make your bond so high, you'll have hair falling out.
Yes,
Do
Your
you
Honor.
understand?
Yes, Your Honor.
Tell me what time of night was, do we know the theft of the tailgate? Was it in the middle of the night?
So it was reported around 5 p.m. That's the only information we have, Your Honor.
I'm ordering you as a condition of your bond not to pick up any new cases, not to have any contact with the complaining witness in the theft case, not to go within 200 feet of where they live or where they work. Do not pick up any new cases. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, and that is also a bond condition. If I find that you're driving without car insurance, likewise, you will go to jail. That's it. If I end up revoking your bonds for one thing or the other, they're probably going to end up around 10, maybe 15,000. And if you don't have anyone to pony up that kind of money, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay, we are going to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. After that, you'll be free to go. Don't be a danger to my city. Do you understand me?
I understand.
Come on. Good morning, Mr. Chimayo.
Good morning.
Good morning.
Charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 27 days in jail with credit for the 9 days that you have done. You need to understand that this charge from now on will go on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 90 days for any new cases, at least with DWIs that you pick up. You ever get pulled over again, officers will see this DWI and they roll up to your window and they smell alcohol, or if they smell dope, it's probably not going to go well for you. So I would never get into a car and drive if you've even had a sip of alcohol. Do you understand?
Yes.
You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal, meaning once you plead guilty, this goes on your record and it will be there for the rest of your life. Is this what you want to do? Sir,
Yes.
is it true or untrue that you had a .15 or above breath test?
True.
Find it is true. I'm now going to send you to the 27 days, give you credit for the 9 days that you've done. I'm going to suspend your license for 90 days. Do not drive until you get a license and good luck to you. Thanks.
Judge, I was appointed to this case about 8 days ago, Judge, and I don't believe any status has changed since then. Can we have the court waive the DPSP? Thank you, Judge.
Okay. Hey, Josh.
Hello, Judge. Can you hear me? Yes, I believe Miss Parks appeared, is my understanding.
Give me a second. Hold on. Let me just talk. Okay, what?
Yes, so it's my understanding Miss Parks earlier, but she's there now, Judge. And so Victoria asked me to
36 Parks, she's set for trial and showed up at 1 o'clock.
Today's your trial setting and you show up at 1 o'clock. Really? I'm sending you for a drug and alcohol test right now, and then I'm rolling your case until tomorrow. You must be back here tomorrow. You understand me? Yes. Please take a seat.
A man with 21 criminal entries since 2020 had his evading arrest case dismissed because the officer stopped him for nothing more than riding a bicycle away from a marked police car near a closed building. No crime was being committed. The Fourth Amendment requires reasonable suspicion of criminal activity before police can legally stop a person. When a court dismisses a case against someone with an extensive criminal history because the stop itself lacked legal justification, does that outcome represent the constitutional system working exactly as intended? Or does it reveal a tension between individual rights and community safety that the law has never fully resolved?
Mr. Mohammed, you're charged with failure to comply with, basically FSGI, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Okay.
Thank you, Your Honor. On March 22nd, 2025, in Harris County, Texas, the complaining witness went to the police station to make a report for someone that struck her vehicle and failed to stop and give information. On March 24th, 2025, the officer reviewed body-worn camera where the complaining witness stated that while she was at a soccer game, someone struck her parked vehicle. The complaining witness stated that another witness left a note, and that witness observed the defendant strike the complaining witness's vehicle and leave without stopping and giving information. The witness stated the defendant was the coach of the opposing soccer team. The complaining witness stated that they talked to the defendant, but the defendant has failed to provide their insurance information. The officer met with the witness who viewed the accident and administered a photo array. The officer observed vehicle damage from the defendant and the complaining witness consistent with complaining witness and witnesses' accounts of events. The officer observed text of the complaining witness communicating with the defendant. In those texts, the officer observed the defendant state he is responsible for the crash and he has no problem paying for the expenses out of pocket. The complaining witness obtained a written estimate of cost of repair to her vehicle of $1,975.78.
Mr. Mohammed, I'm going to find that there's sufficient probable cause to go forward with the case. Does he have a license? You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name.
Yes, Judge.
I'm also ordering you not to go back to the soccer field. Do you understand? If I find that you pick up a new case, if you go back, I will revoke your bond, put you in jail, no more.
Judge, may I? Is there any way we just do no contact with this person? Because in this club soccer world, there's only like 2 to 3 fields that they play on. My daughter's played Albion and there's only like 3 parks that they play out. So can we just
It's happen again. And
I understand. Can we do a no contact so that he's not around that person because he's the head coach of the soccer team? And we're going to get this taken care of pretty quick. I think they agreed that if he pays restitution, they're fine with it.
how is it going to be possible if they're still playing soccer that it's going to?
I think he can avoid them. These parks are big. There's Dice, Zuby Park. Go ahead.
First of all, sir, I've never had contact with the woman who claimed these claims. That's one. Second of all, I never left the scene because I had to.
I'm not going to argue with.
No, of course I understand.
We're not arguing the case.
Sir, sorry. Yes, I'm just trying to clarify that there's no contact between me and the or whoever's making the complaint at this moment. I've never had contact with her in my life, so there's no reason for any non-contact going forward. As I said.
Before he's allowed to drive, I want proof that he's got liability insurance, and I don't want you to have contact with the complaining witness. If I find that you get into another accident, if you're a danger to my city, I'm going to lock you up. Do you understand, Mr. Mohammed? Okay.
Thank you.
All right. We need to put bond conditions. We need to show proof to pretrial that he's got insurance, and then we'll allow him to drive.
Thank you, sir.
Good morning, Mr. Hissa. Good morning. So you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On March 26, 2025, in Harris County, Texas, an officer was dispatched to a vehicle accident. The complaining witness stated he was driving when he noticed the defendant was tailgating him in his truck. The complaining witness stated he brake checked the truck. The complaining witness stated he attempted to change lanes to let the defendant through. The complaining witness stated the truck went around him, got on the median, and then collided with the complaining witness's vehicle on the side. The complaining witness stated the defendant pulled ahead of him and turned to leave the scene. The complaining witness stated he followed the defendant and got in front of his truck to prevent him from leaving. The complaining witness and the defendant exited their vehicles. The complaining witness stated the defendant came up to his face and was yelling that the defendant was trying to find a good place to stop. The complaining witness stated the defendant got in his motor vehicle and left without providing his driver's license or insurance. The complaining witness stated he did not want to press charges. The complaining witness estimated damages to be $500. An officer ran the plate provided by the complaining witness. There was a driver's license attached to the plate. The officers ran the attached driver's license and got a return photo. And the complaining witness ID'd the defendant by this driver's license photo that the officer showed him.
Mr. Hitz, I'm going to find that there's sufficient probable cause to go forward with your case. Do you mind running his license, please?
Sure.
If he has a valid license. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If I find that you drive without either, or if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer?
I think so. Yes.
Okay.
Yes.
We'll give you time. If you have any problems, just come back and talk and then we can go further. If you need an appointed lawyer or anything, we can always have you fill out an application. So for now, I will have you go to Victoria, sign a reset. We will then have you take a seat in the jury box while I get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go. All right? Thanks.
Judge, for what it's worth, my client, assuming the court's okay, would like to apply for an driver's license after this. And we'll be working on getting those documents together as a closing time.
I don't know about doing a time served. He just had one that's dismissed and he's back now, right again with another DWI, and it's a point, and it's above a 15. I mean, really?
Sure.
We're still going to continue to do the same thing over and over and over? No, I know you're saying no, but here you are yet again. You had one dismissed, you know, a year and a half ago. Now you're back on another one. It's above a 0.15.
If you got an occupation, the court could order some level of treatment, Judge.
He has to do treatment as part of it. So what we do is we have him TRAS'd, you know, but if I accept this, I'm sticking him with the fine. I'm not going to let him go without the fine.
Would you impose a fine on the probation?
No.
Let me talk.
Talk to him. It's 4,500 as well, too. No, I'm sorry, 6,000. You know, I need you to understand that in life, right, we're not going to continue to hope and pray that something bad doesn't happen. We sometimes have to take proactive measures to ensure. You just had one dismissed. You've now picked up another one. If I were to plead you to time served, another proverbial slap on the wrist, and now we're going to let you go out there and hope that you don't kill someone or maim someone or you don't pick up another one, you know? No, that's like the definition of insanity, in wishing that something, you know, over and over, just with a different result. No, this is proactive because here we can see what the issue is. You know, we don't want you to come back with another DWI or much more kill someone, because I mean, look at the news. Every day someone dies from a DWI, and it's just not fair when it's so freaking preventable by one damn button on your phone. How much money have you spent on both DWIs so far, where one button and a $40 fee would have gotten you from A to B? You know what I mean?
Sir.
That's now what we have to do to intervene in hopes that you learn from this so it doesn't happen again. So you've worked out an agreement where they're offering you 1 year in jail, and this is to be probated for 15 months. As part of this, you will do a repeat offender DWI education class, a victim impact panel, a TRAS, which is an evaluation to see what are the conditions you may need, if you need other conditions. If they assess them, you must fulfill them. No drugs, no alcohol, no breath test refusal, meaning that if you're pulled over, an officer asks you to submit a breath test, you must do it while you're on this probation. Guardian interlock, 25 hours of community service, and a $100 one-time donation to Mothers Against Drug Driving. You have children.
No, but I have a 13-year-old brother that relies on me.
If he does a parenting class, then I'll consider the community service way. The idea, all we want is that you learn, so that you, in 20 years, this has made enough of an impact on you that you think twice. Oh man, shit, that was such a bad experience. I don't want to do that again. It's either jail or it's a crap load of fines and fees. Do you understand?
Yes, sir.
If you ever have a problem while you're on this probation, all you have to do is come back, let us know. We can work through anything. There's nothing too big, nothing too small. But the worst possible thing you can do is drive without a license or insurance, start using, or pick up another DWI. So you understand?
Yes, sir.
The other thing, that if you just take off, abscond, that's also instantaneous warrant. If you violate this probation, that's what we do. We issue a warrant. We have a hearing to determine whether you violated it. And if you do, you're looking at an entire year. Do you understand?
Yes, sir.
You give up the right. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, this is going on your record now. It'll be there for the rest of your life. Do you understand?
Yes, sir.
From now on, you're facing a minimum of 90 days in jail. You ever pick up another one. Do you understand?
Yes, sir.
And I'm going to tell you now, you get pulled over, an officer, the first thing they do is they look at your record. They're going to see DWI, DWI. What do you think they're going to do? Do you think they're going to harass and harangue the hell out of you? Every time you get pulled over. And if they smell anything funky, it's probably not going to go well. Do you understand?
Yes, sir.
Is it true or untrue that you had a 0.15 or above in this case? True. True to the enhancement. All right. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to follow this agreement. I'm going to send you to it. I'm not going to suspend your license now, but I'm going to tell you, can you look up his license? Let's just see if it's his number.
Judge, I'm sorry, I missed his name.
Arredondo.
This is not eligible, Your Honor.
Okay. So you will be signing a non-driving affidavit. If you drove here today, you were not allowed to drive home. Your license is suspended as of this time. If we catch you driving without a license, I'm going to lose it. Do you understand?
Yes, sir.
Do not drive. You are required to have a guardian interlock, and every officer, because we send notice to DPS, every officer in the state knows if they pull you over and you don't have an interlock, you're going to jail. Do you understand?
Yes, sir.
That's for the traffic, right? That's why he's ineligible, right? So
I
traffic.
think, believe so. I took care of those yesterday. So.
Okay. Judge, I believe his license may be showing ineligible due to a traffic ticket. If we can get that sorted, can we come back and?
I'm okay with an occupational as long as he's in compliance, okay? The other thing is this, is he is now taking a subsequent DWI education class. DPS is probably going to suspend your license regardless because of a subsequent DWI education class. If you've already taken it, did he do a diversion and it got dismissed? As part of the diversion, you have to do a DWI education class. Subsequent ones get your license suspended. So I would check with DPS first. Don't just start driving, when you take care of that ticket, because they're going to probably suspend your license again. And this time it may be like a 2-year suspension. I'm okay with an interlock, with an occupational, as long as he's in compliance.
Yes, sir.
And he has an interlock first. Okay. All right. So we're going to have you meet with Shatoria for all your conditions and then good luck to you, sir.
Yes, sir.
Thank you. Wade, the supervisor. Good morning, ma'am. Good morning. You were charged with driving while intoxicated. You were facing up to a year in jail and or a $4,000 fine because of the high blow. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that you're entering into a very important agreement today where this DWI will go on your record. It's going to be there for the rest of your life. This is serious business because if you ever get pulled over again and you have some kind of funky smell, whether it's alcohol, whether it's dope, anything, it's probably not going to go well for you because they're going to look that you have a prior DWI. And you understand?
Yes.
So I would never, even if you've had a sip of alcohol, get into a car because you're begging for trouble. We all make mistakes, but when you continue to make mistakes that you endanger other people's lives, the sentences get longer. The costs go skyrocketing. You understand?
Yes, I do.
So there is a $6,000 surcharge that would tack on because this is a 0.15. I'm going to waive it for you today. If you come back with another DWI, get ready because it gets a whole lot worse. Not only that, from now on, it's a minimum of 90 days in jail. You pick up another one. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Is this what you want to do?
I understand.
Okay, how do you plead to the offense, man? Guilty or not guilty? I'm going to find you guilty. Send it you to 3. Is it true or untrue that you had a 0.15 or above?
It's probably true.
Okay. Do the enhancement. Okay, I'll send you 3 days in jail, credit for the 1 day that you've done. I'm going to suspend your license for 90 days. Do not drive until you get a license. I'm going to waive your supervisor fee, but be careful. You come back on another one, it's going to cost you an arm and a leg. Do you understand? For $50, an Uber, wherever you want to go, $50.
That's what I'm doing now.
Good. Good luck to you.
Yeah, and I do have a question. There is something weird with her license. We're unable to get a status of her license.
Yes, absolutely.
I think state did just a few minutes ago too, and they couldn't do anything.
Gaskin, his last name, I don't know. You know, that's something you may just have to call DPS to figure out. You have your license number, correct?
Yes.
This is the number that we ran, that's the number to the driver's license division of DPS. Call them right when the phone line's open at 7 and you'll get through. Don't try at 7:20, 1 o'clock, you'll never get through because they're so busy. But if you call right at 7 o'clock in the morning, you'll be able to speak to someone and they can tell you what the problem is.
Judge, even our arm, it won't populate, it won't return to anything. I'm not sure.
There's something's wrong. I don't know. I mean, we only get access to be able to put a number in and it'll spit out information as to the status of the license, why it is. I don't know. Maybe it's got to be an incorrect number or something. Maybe
It doesn't populate the number, which is odd. It's just a symbol and then it says error.
Because in the one in that letter, it was saying something about
The website could be down too.
do something.
Oh, yeah, maybe the website's down. I don't know.
Or something.
I would call them. The best thing to do is just call them. Then you can hear it straight from them. You know, that's what I would do.
Right. And I do have one more question here. I'm sorry. If we find that her license was previously suspended for 90 days, would you be willing to give her credit for that 90-day suspension?
Yes, but you have to give them the dates and everything.
Gotcha. Yes, sir. Thank you, Your Honor.
Approaching on Francisco Ochoa.
Okay, let's hear Mom.
He's on bond.
Page 24.
So, Judge, the court wanted Mr. Ochoa on docket today, because there was a new case that he was charged with. An assault that happened in the jail. He's currently on bond for tampering. There was allegedly an assault that happened at the jail. Yesterday I came into the court. Richard and I watched the jail video. There's absolutely zero participation from Mr. Ochoa in the fight in the jail. It's all on video. Zero participation. He's clearly in the video sitting down. That's the state. You have to ask the state that one. I have no idea. So Richard's been communicating with the felony prosecutor. He hasn't got a response yet. Currently, there's a warrant out for Mr. Ochoa's arrest.
Well, not a warrant. He's being held at no bond on the assault now, right? He's back there, right?
No.
Where is he now?
There's a warrant out for his arrest. He's in the building right now.
Right. I'm not going to do anything until I know where he is and we have him, right? If he's out on the lam or just out and about, I'm not doing anything until he's here, you know? If you want me to address it, we do PC. I'm happy to do it, but not till he's here. I'm not gonna, he's gotta be here.
Because if he comes in.
I have he's in jail. I'm showing he's in jail for some reason.
So.
Are you not? It shows jail. Okay, so I'm happy to go through everything with you, but I'm not gonna do it till he's here, you know, really. And if it is what it is, I mean, he's about as reasonable as. Show him. Maybe he'll dismiss it
We
now.
just
I don't
watched
know.
it again today. We watched it twice. And
He doesn't want to dismiss it?
he wants to communicate with Richard.
Oh, he wants to talk to felony for something?
Right. But this is a misdemeanor case where.
Regardless, Mr. Hager, I never do PC without the defendant being in here to do it, you know, and that just goes with everything. With every single case, I never do PC unless they're here.
Understood.
You know, if you want me to do PC, I'm happy to do it, but they gotta be here. And then we'll do it. And then I'm happy to watch any videos that you have as well. We'll watch it all together and we'll make a decision.
Yes, sir.
I'm trying to be as reasonable as I can, you know?
All right, thank you.
All right, so good afternoon, Mr. Hodges. So your charge is failure to stop and give information. You have worked out an agreement where they're offering you a 6-month deferred. This is a type of probation that if you complete successfully, you do not end up with a conviction on your record. But you cannot tell people it was dismissed. It does not get dismissed. You merely take a probation, complete it successfully. You don't end up with a conviction. Do you understand?
Sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned, charge rates in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this, there's no turning back. Do you understand?
Yes, sir.
Is this what you want to do?
Yes, sir.
Was there no restitution that was due in this? Hey, Blaze, on Mr. Hodges, was there any restitution that was due? It's an FSGI. The agreement that I see so far is a 6-month deferred. No drugs, no alcohol, random testing, and 20 hours of community service.
There's no monetary damage, Your Honor.
No? Okay. Do you understand this?
Yes, sir.
I want you to get this done quick and there's no problems and you're nice to everybody, especially the probation officers, I'll take you off and half the time as a reward.
Yes, sir.
But if you pick up a new case, you take off, if you do something to violate this agreement, I will issue a warrant for your arrest and you're looking at 180 days in jail. So you understand?
Yes, sir.
All right. How do you plead to the offense? Guilty or not guilty? No. It's either guilty or it's not guilty.
Guilty.
All right. I'm not going to find you guilty now. I will withhold that for 6 months, give you the opportunity to complete it. And if you complete it, that's when you don't end up with conviction. If you violate this, though, we put you in jail, bring you out, we'll have a hearing. And if you violate it, like I said, you're looking at 180 days. Do you understand?
Yes, sir.
Okay, good luck to you.
Thanks.
Would you like Mr. Ochoa to come up?
Huh?
Would you like Mr. Ochoa to come up?
Not yet. He's here, though, right?
Yes, sir.
So I mean, I've watched the video, Your Honor. From what I can see in the video, it appears he's sitting back. I'm being honest with the court.
Just the whole time, there's not participating in this all. Does he provide some kind of assistance, encouragement? Does he say, hey, go get him? Or
So the video,
is it a party type?
honestly, the video doesn't have any audio, so I don't know if he's encouraging them, but it does appear that he's just sitting back on the bench.
So how would they find probable cause?
Unless they did not do their due diligence and put the finger on the wrong guy. Simply, period. It's clear as.
Cops will say, hey, look, this guy's a party to it. He was there. And they don't get access to the video to see it. And maybe they just, when they're doing magistration, they don't go through the video to look.
I mean, at the end of the day, Judge, with all due respect, before you charge somebody with the criminal offense and putting their freedom at stake, they need to make sure that is who they say it is. There's a number of people that beat the brakes off of somebody in jail, and Mr. Ochoa had absolutely nothing to do with it, period. He's sitting on a bench from a distance.
But I'm not, you'll find no argument.
And now there's
no idea.
And now there's an open warrant for him, which definitely would affect this court's case as well as the felony.
Look, because sometimes they'll give me information on how someone found probable cause, right?
So, I mean, in the offense, there's an offense report saying that he was stomping and punching repeatedly the complaining witness. And it's clear as day, he didn't.
They got the names wrong. There was a Francisco Ochoa, there's a Francisco, so there's different Franciscos. Maybe they got it mixed up.
So the cause number is 255-9198. And I have the video queued up if the court would like to see the video.
He's corroborated. I trust Blaze, I trust you guys,
Yeah, I'm being transparent.
Yeah, that's. Oh, so this is a 2B.
Yeah.
The warrant.
Yeah, it's a 2B, so he's never even gone before magistrate.
Well, so
I just won't sign the 2B. I mean, hot dog it, then we're gonna have that other problem, because it's always gonna show like a warrant.
So if you, what if you can find the PC? Is that what you're doing?
Yeah, I'm gonna find, I guess I'll sign it and say no PC on.
Generate the PC forms separately.
Okay, I'll do that. Blaze, I'm gonna find no PC if that's what it is.
Sure, Your Honor, I'm sorry.
It's okay.
I'll reach out to felony before it's dismissed. I mean, I've looked at it, being candid here, me and Brad have talked about it. Never show the felony, I'll have an in-person conversation.
Yeah, do it sooner rather than later, because it's gonna show always warrant status until it, gets dismissed, right? I'll find no probable cause.
It'd just be defendant discharge.
Is that right?
Yes, Judge.
Okay, so that way, because I don't want them to get pulled over and someone says, okay, so it'll show defendant discharged.
It's not dismissed at this time.
Yeah, they have to dismiss it for it to really go away.
The warrant summons to generate, we'd have to take it to grand jury and get it done. I'm not saying we're doing that, I'm just saying that's how the warrant would generate.
So I'll find no PC.
Okay, all right, thank you, Judge. Thanks, Rich.
Yeah.
So Judge, I have two people talking about.
Okay.
Is, just our Neil. Yeah. So I was able to talk to his father finally, but he was at the hospital
checked on his wife, and he wanted to talk to me later. So I don't have an answer yet about, the home and everything, whether or not.
Roll it till later this week and I can waive his appearance.
Sure.
And does he have a cell phone or no?
No, he doesn't have his cell phone's at the house, and his ID and everything's at the house, because they arrested him basically in his underwear. And so,
She said that she's willing to put it outside the house, right? You want to schedule a time that he can come get it? Perhaps you guys just coordinate a time.
Sure, do that.
Just tell him not to knock on the door, try to have contact with her, just literally pick the stuff up and go. They've got in garbage bags ready for him, so just coordinate a time.
And so right now he didn't have anywhere to stay. He's staying at Star Hope, and every day he has to take everything with him. When you leave there.
I know.
But he can go through, I guess, and pick out what he needs, and then, go from there. I did talk with his sister, and the family's trying to help him.
Say with his sister. Here?
Sorry?
Where's sister here?
She's in North Harris County.
But he stay with her?
No.
Let him stay.
Yeah, she doesn't want to have him stay with her. Muskie Road, way out there, 2290. It's kind of far.
You don't want him to stay?
No. But she's not over the house and all that. So, but the dad was. He just couldn't talk to me. He was. I didn't have a number for him, so I kind of knew where the hospital was based on his description. So I tracked him to the hospital and.
Alienated. You have nowhere else to go. But I mean, my fear is that if he goes back to the house, more bad stuff's going to happen, and that's what we're trying to prevent. You know what I mean? I mean, shut. Yeah, Harold, I'll do whatever you want to do if you want to.
Sure.
Set a week, a day, or later this week, whatever.
Can we say like next Monday? That'll be good.
Whatever.
And between now and then, I guess if
Right. I mean, what I would say is if you could reach out to her, ask her what's a good day and time for him to come pick the stuff up, so she knows that she's not there, right? Maybe at the time when someone else is there, so that someone sees him getting it. So don't leave it just out by the front so someone else can take it. Maybe leave it in the backyard, or just be conscientious, because we don't want someone else to take it, and then, or maybe she can be there, and that way she leaves it out right before he comes. That way someone doesn't take it. I don't know.
Right.
Harold, what do you think?
Yeah, we'll say Tuesday. I don't know, maybe if she could do, I guess we kind of need to know what day. Could you reach out to her now? You think she's available, or?
Yeah, I can reach out to her.
See what Wednesday or Thursday is a good day.
Yeah, and do you know what time that would work?
You guys decide that off so that I don't want to get involved, and I don't want to live stream everything that,
And then Judge, we also had Mr. Savage in the holdover. And he has an MAJ. He's MAJ in here on probation case. But while he was in drug treatment for the probation, he picked up another case. And then I think after he got out, the story I'm getting is after he got out of the probation.
Yeah, so he got placed on probation back in 2022 for an assault. He completed a part of that probation. He was to go to SAT. And while he was there, he picked up a felony charge. They ended up putting him on probation. And then while he started going to aftercare, he tested positive for amphetamines, meth, and benzos, and then he just responded from both our probation and the police probation.
Okay.
Because that's why it's been a couple of years, right?
Yeah, I guess it's time to let's be done with it, right?
Well, he was asking me, I don't want to speak for him. I can't remember if he told me he's clean now, but he was interested in trying to restart everything.
I mean, really,
too far out.
You get on the assault with us. While you're on probation for assault, you pick up a felony. While you're on both probations, you start testing and then get abscond. I
think the felony was getting drugs while you're in the program. So, I think it's really a drug problem. It's not a.
Yeah, unfortunately, we don't have as many tools as felony courts has to address, and I don't know what they'll do up there. Perhaps they'll put them back on there and keep them in treatment. I don't know, but
Is it possible to, wow,
This thing's been going on for 2 years, you know?
how much did we complete at it? And that's what that part.
My feeling is probably nothing because he's been in treatment for, in treatment or it's gone.
And he's behind his feet in the aftercare. So that's participant.
So this is the kind of thing where we could terminate unsuccessfully, let him deal with the felony.
I mean, I'm willing to give him back time, but true to the, you know, I wouldn't want to unset term him because that would, in effect, he wouldn't end up with the affirmative finding thing, you know, and so I'm willing to do the back time, but you know, you'd have to, you know.
We're just not sure if that'll affect his felony one. Yes, it wouldn't, because it predates the felony. So it wouldn't, yeah. Okay.
If you want a couple days to do research and think about it, I'm okay with it too. You want to do that?
You do that? Yeah. Sure.
So set it for maybe next week, take a look. But I mean, Harold, I mean, really, are we going to put him back on when he hasn't done anything? Get absconded, had dope while he's in treatment, and then he's still doing while he's out.
Just sounds like we didn't commit to it initially. You know, we weren't really struggling with it, with the addiction, maybe, and not committing.
I get it, but at some point we have to say when. And I think that's done. But I'm willing to give you time to look to see, and, you know, maybe getting contact with a felony lawyer to see, you know, whether it would have any kind of impact or not, you know? So you pick the day, whatever you want. All right? Okay.
Thank you.
So this docket today gave us something we have not seen quite so plainly before, the system catching its own mistakes in real time. A bicycle rider dismissed. A jail assault charge dropped because a defense attorney queued up the video and said, "Watch this." A defendant told to pick up his belongings from a garbage bag outside his own home while staying at a shelter. And somewhere in the middle of all of it, a quiet conversation about a man named Savage, 2 years of probation, a felony picked up mid-treatment, meth found while in a recovery program, and a judge asking out loud the question that underlies so much of what we have watched. At what point do we say when? 13 sessions have shown us a court that almost never gives up on people. That is its greatest strength. But today also showed the cost of that persistence, in time, in resources, in the slow accumulation of cases that never quite resolve. There is a difference between a system that believes in second chances and a system that has no mechanism for anything else. Knowing which one you are watching is, perhaps, the most important question this courtroom leaves unanswered.